The killer walked free on bail. And there was nothing the victim's family could legally do about it. But one mother refused to accept that. She spent 30 years rewriting America's Constitution, state by state. November 1983. Marsalee Pollard received the phone call every parent dreads. Her 21-year-old daughter Marsy had been murdered by her ex-boyfriend in California. But what happened next would haunt her almost as much as the murder itself. Days after the killing, Marsalee walked into a grocery store. Standing in the checkout line directly in front of her was her daughter's accused killer. He was out on bail. Nobody had told her. Nobody was required to tell her. And that's when Marsalee discovered a truth that would consume her for the next 3 decades. In America's justice system, criminal defendants have extensive constitutional rights. But crime victims? They had almost nothing. No right to be notified. No right to be present at hearings. No right to be heard before sentencing. The Constitution protected the accused but forgot the victims entirely. If this is already making you question the justice system, hit that like button. Now here's where it gets even more shocking. The gap between defendant rights and victim rights wasn't an accident. It was by design. The Founding Fathers were terrified of government tyranny. They'd seen innocent people railroaded by the British Crown. So they built extensive protections for the accused. The right to an attorney. The right to confront witnesses. Protection against unreasonable searches. These were revolutionary ideas. But in 1789, nobody was thinking about victim rights because victims were expected to prosecute their own cases. The concept of a public prosecutor was still decades away. By the time government prosecutors became standard, the Constitution was already written. And nobody thought to update it. Victims were simply forgotten in the system designed to protect everyone else. But let's look at this from a different angle. Marsalee Pollard wasn't alone in her outrage. She had a powerful ally. Her son Henry Nicholas wasn't just grieving. He was building a technology empire. By the 2000s, Henry had co-founded Broadcom, making him a billionaire. And he never forgot what happened to his sister. Never forgot seeing his mother's face when she encountered the killer at that grocery store. In 2008, Henry launched his plan. He would fund a campaign to put victim rights directly into state constitutions. They called it Marsys Law, named after his murdered sister. The first target was California. Henry poured $6 million into the ballot initiative. Television ads flooded the airwaves. Crime victims told their stories. On election day, 53% of California voters said yes. The state constitution now guaranteed victims the right to notification, protection, and to be heard in court. Think about that for a second. One family's tragedy had just changed the constitution of the most populous state in America. But California was only the beginning. Henry Nicholas had proven the model worked. Money plus emotional storytelling plus ballot initiatives equals constitutional change. And this is where a question nobody can answer becomes crucial. What happens when victim rights clash with defendant rights? Because that's exactly what started happening. Over the next decade, Marsys Law campaigns swept across the country. Illinois, Ohio, Georgia, North Carolina, Florida. Each time, millions of dollars funded sophisticated campaigns. Each time, voters overwhelmingly approved. By 2024, 14 states had amended their constitutions. But defense attorneys started raising alarms. They argued these new victim rights were creating unexpected problems in the courtroom. Problems that would challenge the very foundation of American justice. But here's what nobody tells you about Marsys Law. Some victim advocates actually oppose it. And this is where the story takes its most unexpected turn. Organizations like the American Civil Liberties Union argue these amendments are dangerously vague. What does a victim's right to reasonable protection actually mean in practice? Who decides what's reasonable? More troubling, in some states, Marsys law has been used to hide the identities of police officers who shoot civilians. The officers claim they're victims of assault. Suddenly, victim rights become a shield against police accountability. Then there's the money question. Subscribe if you want to see how this unfolds. Critics point out that Henry Nicholas has spent over $100 million on these campaigns. They question whether constitutional amendments should be purchasable by billionaires. Even some crime victims have spoken out, saying Marsys law prioritizes vengeance over healing. The movement that started from grief had become something far more complicated. And then it got worse. Several states saw their Marsys law amendments challenged in court. South Dakota's version was struck down by the state Supreme Court in 2017. The court ruled it violated procedures for constitutional amendments. Montana voters approved Marsys law in 2016, but implementation was blocked for years due to legal challenges. Even in states where it survived, prosecutors reported confusion about how to apply the new rights without compromising fair trials. Here's the fundamental tension nobody has resolved. The Sixth Amendment guarantees defendants the right to confront their accusers. But Marsys law gives victims the right to refuse being interviewed by defense attorneys. What happens when these rights directly conflict? Drop your prediction in the comments. Courts have struggled to balance these competing interests. Some judges prioritize victim comfort. Others say defendant rights must come first. There's no consistent answer across America. So what's the verdict on Marsys law? The big reveal is that there isn't a simple answer. And that's precisely the point. Marsalee Pollard wanted one thing. No other mother should face her daughter's killer at a grocery store without warning. That's an undeniably reasonable goal. But constitutional amendments are blunt instruments. They create rights that apply in every case, regardless of circumstances. The 14 states that adopted Marsys law are now living laboratories. Some crime victims report feeling empowered for the first time. They attend hearings. They make statements. They feel part of the process that previously excluded them. Others say the laws haven't changed anything meaningful. Meanwhile, defense attorneys document cases where these amendments complicated fair trials. Innocent until proven guilty means less when victims have constitutional rights before any conviction occurs. The system is still adjusting. Marsalee Pollard died in 2011. She never saw Marsys law spread to 14 states. But her legacy poses a question America still hasn't answered. Should victim rights be constitutionally equal to defendant rights? Or does that fundamental imbalance